one. Hey, yo, welcome to Damu Kiwe Conversations. Salute to the whole team. Hey, yo, we got the content. Salute to the whole team once again. You talking about that girl Henny, Smoked Out TV Reactions, Scandalous, Los Angeles TV. The brother would be with us, but he's currently in SA, that's Strippers Anonymous. He had this addiction to early morning strip clubs. So we got the brother some help. Salute to him. Keep him in y'all prayers. But I got my player partner Yael, the hub and the judge.
Hey, listen, man. Damu Kiwe Conversations. I know they hate when we hit. Hey, I know they hate when they see DuseM's, Bremenem, and Yael pop up on their damn timeline. I know they do because we coming with receipts. So open up the collection plate and let's receive the blessings that the Most High has to give. Hey, we have the Levitical priest, DuseM.
Well, my nigga Papa Dirt. Well, first, let me shout out everybody in the chat. And then, first, let's start with Clubhouse. The loyal supporters. Clubhouse is a dying app for those that pull up because they know we got the content. Salute to Stand On It Media. Brother Talmir, Bomani, what's up, baby? I told y'all we got the hub, Yael, and the dub. My brother Bomani, man. Salute to I'ma call y'all back. G-Mac is in the building. Pacoima is in the building. Salute to everybody else who came through and supported, even bullshit ass TD, but salute, that's my brother from another. But Smoked Out TV Reactions, salute the minor Ulysses, free Suge, definitely free Suge, man. We wouldn't wish jail on our worst enemigo. Papa Dirt, another Damu Kiwe Conversation exclusive. Bees and Crips, let's get it. Deuce and y'all strong. And the whole Damu Kiwe conglomerate. That's a fact. Richie Rich, I just seen you come in. Shout out to the booby trap in the booby trap. Show me your boobies. Yeah. But salute though, Papa Dirt. You know what I'm saying? Pee-wee for life. Okay, what up, Pee-wee? Salute to you, Slimeball TV. One thing about Slimeball, he don't say too much. He just be looking with your looking ass. You know what I'm saying? That girl, Henny. Yeah. What's popping, everybody? Be sure you smash that like button on the way in. And don't forget to throw them chucks in the chat. We got the content. Henny already know what time it is. But don't put the chucks without the Henny glasses. They go hand in hand, man. When you kicking back, feeling like a real rider in your active chucks, sipping on some yak. Hold on, let me get my little cup. You know what I'm saying?
Oh, okay. He got the L on there for Lamonte.
Lamonte. You know what I'm saying? That nigga gonna be, he got an L on his cup for Lamonte. Yeah, that's my name, bro. All right, Pee-wee for life, I see you. All right, Evelyn Holly, salute. Nah. Okay, I see the Henny glass and Jenny from the block with that pity in her PTR picture. Stacy Taggart, salute to you. Hey, this is going to be good. Make sure to hit the like button. And you 100% show, hit that like button. Uniquely yours. We finna get into a Steffi Weffy. And the whole team is up in here, man. We getting all the way down. Showstop in the field podcast.
You got this bullshit dude in the chat. This is a bullshit dude, bro.
Do not shoot shortstop in the field podcast. That's our personal troll. He's here on business. This is what he does. Hey, we got to get him a blue wrench. Somebody please give him a blue wrench, because he gonna know what to do with the trolls that come through. He's a gunner. You know what I'm saying? Paris Ty, salute to you, King. I see you down there. Monique Hill. I was just finna start without saying money grip. West LA Trades. I see you, boy.
Salute, salute.
Salute. My Keyways is down there. Sagittarius Jones. Salute DuseM. Salute y'all. Peace to the chat. Hey, man, salute to you, King. You know what I'm saying? But this shit is a lot of paperwork. We got the actual paperwork. I'm gonna send the thing down for Henny just in case she want to come up, because there's gonna be a lot of reading for me. But that's okay, because for y'all, you know what I'm saying, we're gonna take a couple hours out and make sure we get through it, because it's interesting. Suge Knight, you know what I'm saying, coming home. Breaking news by Damu Kiwe Conversations. So we definitely, you know what I'm saying? Oh, well, this is the motion. State Bar, Kenner Law Firm. If y'all don't know who David Kenner is, historic lawyer, which showed me just looking from afar the importance of making sure you got a good relationship with an attorney, an entertainment attorney. If you in this industry, it can make the difference. It can make and break your career. So artists that's out there, executives that's out there, make sure you obtain that. But yeah, you got all of that information there. And that's the attorneys for petitioner Marion Hugh Knight Jr. Marion Hugh Knight Jr., also known as Sugar Bear. Suge Knight, or as if you getting carried real greasy, Simon, because Simon says. But I don't think y'all know too much about that. But look, Henry Marion Hugh Knight Jr. is on habeas corpus in the Superior Court of California, County of Los Angeles, case number TA136401. Marion H. Knight's reply to amended informal response to petition for writ of habeas corpus. So for those who don't know what a writ of habeas corpus is, it's only you not arguing just facts in your case. You have to prove that one of your constitutionally guaranteed rights has been violated. That's the standard to get any kind of relief from the courts. So, to the Honorable Laura F. Priver, judge of the Los Angeles County Superior Court, and to Los Angeles County District Court Attorney Nathan Hotchman and Cynthia Barnes, his deputy. Petitioner Marion Hugh Knight Jr., by his counsel, David E. Kenner and Marcia A. Morrissey, files this reply to the prosecution amended informal response to petition for writ of habeas corpus. Informal response. 1. Introduction. The Office of the Los Angeles County District Attorney alleges that Mr. Knight's petition was not timely filed, and 2, his vague, speculative, and conclusory claims are not supported by credible evidence. Amended informal response to petition for writ of habeas corpus at page 2. First, this petition was timely. It was filed as promptly as the circumstances allowed, and they cite Robinson versus Lewis, and without substantial delay, after Mr. Knight knew or should have known of the information supporting the legal basis of a claim. Henry Lucero. In addition, even a claim raised after a substantial delay will be considered on the merits if the petitioner demonstrates good cause for the delay. Robinson versus Lewis, 9th Cal 5th at 899. As will be demonstrated, Albert DeBlanc did not send legal materials requested by petitioner that were necessary to prepare the petition. Mr. Knight is blind in one eye and has reduced vision in the other, making it difficult to read any legal records he received from other sources. From March 2020 until July 2022, the California Department of Rehabilitation and Correction was on lockdown due to COVID pandemic, i.e., no visitation, reduced movement within the prison, and limited access to the law library. and Mr. Knight reasonably awaited expected testimony in a civil trial based on the same events as this case, which began in May 2022 and ended in June 25th, 2022, with the jury deadlocked 7-5 on battery and negligence. Second, respondent, rather than assess the sufficiency of the petition, respondent being the government, right? The district attorney's office, etc., frames its informal response as if it is a quasi-return and debates the merits of each claim. This exercise is premature. At this point, the court must determine if Mr. Knight's habeas corpus petition satisfies the basic pleading requirements of Penal Code subsection 1474, i.e., states a prima facie case for relief and alleges claims that are not procedurally barred. If those pleading requirements are met, an order to show cause must be issued. So he's basically telling them they didn't jump the gun on arguing the merits when first the court has to rule and meet these statutes and requirements to determine whether or not relief is necessary under the law. The habeas corpus petition in this case, 1, alleges unlawful restraint and names the person by whom petitioner is restrained. 2, states fully and with particularity the facts supporting relief. And 3, is supported by reasonably available documentary evidence. It therefore satisfies the applicable pleading requirements. See Penal Code subsection 1474, People versus Duval. This court should order the prosecution to show cause why Mr. Knight is not entitled to the relief sought, grant petitioner the authority to obtain subpoenas for witnesses and documents that are not obtainable by other means, grant him the right to conduct discovery, and order an evidentiary hearing at which petitioner will present further proof of the factual allegations in the petition, right? 2, reply to the respondent's statement of facts and statement of the case. The informal response to the habeas corpus petition is replete with statements of fact that are unsupported by credible, admissible evidence. Worse, these facts are largely irrelevant to the determination of the issues raised by the petition. The only conceivable reason for inclusion of such material in the statement of facts is to prejudice Mr. Knight by unfairly portraying him as someone undeserving of the relief he seeks. For example, the prosecution's statement of facts asserts that Mr. Knight is one of Los Angeles County's most prolific and high-profile criminals, ID at 3. In fact, Mr. Knight had a single case for which he earned stripes. In 1996, he pled nolo contender, which is no contest, to 2 counts of assault with a firearm. This is not the record of a prolific criminal. Respondent includes a description of a highly publicized incident in 1996 involving Mr. Knight, Tupac Shakur, and others at a casino in Las Vegas that occurred just hours before an ambush in which Mr. Shakur was fatally shot and Mr. Knight injured. It states that MGM hotel surveillance cameras show Mr. Knight clearly kicking the victim numerous times in the head. I think that's a stretch. ID at 3. In fact, the video does not show Mr. Knight kicking anyone. An MGM security guard, after reviewing the entire incident while testifying in court, was unable to identify a single strike by petitioner. A martial arts expert who viewed the video, and then here goes, this is a little at the bottom, a side note, right? Mr. Knight challenged the validity of the pleas entered in that case in the trial court, BA, and that's the case number, the California Court of Appeal, and then that's the appellate number, and the California Supreme Court, and that was the number filed to the Supreme Court. He filed a petition for writ of habeas corpus as to the probation violation, finding and sentence in the California Court of Appeal and the California Supreme Court. He also litigated the validity of his no contest pleas and the probation violation finding and sentence in a petition for writ of habeas corpus filed in the Central District of California. And then there goes the case number. But back to what I was saying, a martial arts expert who viewed the video testified that Mr. Knight was not attempting to injure the alleged victim at any time. And the victim, Orlando Anderson, testified that Mr. Knight did not assault him in any way and had in fact tried to break up the scuffle. Let me wet my whistle real quick. This is a lot of reading. Yael, you with me, King?
Damu Kiwe Conversations. Hell yeah, man. Listening to this interesting, informative paperwork, man. The whole manuscripts. Let's get to it.
We back to it then. Respondent includes a description of its version of the facts in two cases that were dismissed pursuant to the plea agreement in this case. One of these cases, SA in the case number, charged as a robbery. The theft of a camera from a female paparazzi on September 5th, 2014. This event occurred just 2 weeks after Mr. Knight had been shot 7 times. Mr. Knight, who was still recovering from his injuries and wearing pajamas, was walking with his 4-year-old son and co-defendant Makai Williams. Talking about Cat Williams. Hey, Yael, you got that Cat Williams down pat? Why don't you tell us what happened when you and Suge got raided by the paparazzi? What went down, man? Yeah. Oh, he at work. I forgot he was at work, so he'll be in and out. Damn, that would have been real funny. But anyway, when they encountered aggressive paparazzi, Mr. Knight was in no condition to react. It was Makai Williams, not Mr. Knight, who chased the female photographer and grabbed her camera. Cat Williams entered a plea in this case and was sentenced to 2 years probation and a $250 fine. Exhibit 1 at 169, lines 1 through 6. The second case, case number, charged a single count of a criminal threats, Penal Code subsection 422, occurring on August 8, 2014. From 2014 to 2016, no charges were filed as a result of this incident, likely because complaining witness reported that he was not afraid, would most likely not press charges, and there were subsequent overtures that they should make peace and let it go. However, in February 2017, while this case was pending, the criminal threats case was resurrected and presented to a grand jury. So they more than likely presented that to prejudice him before the eyes of the jury. Common tactic used by district attorneys to get somebody where they find it might be a robber case and go to the defendant's way, prejudice him, might even say that he's a gangbanger, dangerous, when he might be as soft as a marshmallow, kind of like, sweetie, soft like that nigga. But despite an extremely and uncooperative complaining witness, an indictment was obtained based on prior inconsistent statements and cell phone data. The prosecution also includes in its statement of facts events in which Mr. Knight had no involvement. It discusses a case in which Mr. Knight was not charged, a violation of court order by the sale of a video to TMZ by Toy Ken Kelly and Mark. Hold on. There go Henne.
What's poppin', bro? Don't ever do that again.
What happened? What happened?
Don't ever do that.
Sweetie. Well, I was talking about with how they lie and person could be soft as that nigga. So everybody knew who it was. I didn't even want to say Loose Coochie Ashley. They know who that is. You know what I'm saying? But I might need some help reading so I could wet my whistle. But I'm just getting started. So let me get at least in 15, 20 pages. You know what I'm saying? And
yeah, it's a long one.
Yeah, this is a long one. Did I already send it to you?
Yeah, you sent it to me. I have it pulled up. I apologize for my tardiness, everybody. But what's poppin', y'all?
Yeah. You already know Yael at work, so he'll be in and out. I was dying, praying, hoping he had enough time to jump into the Cat Williams. You know, he's the ventriloquist.
Right.
So I wanted to see if he could have pulled that Cat Williams off. You know what I'm saying? But
that would have been a good one.
yeah, but I told him he need to do some shorts with Cat Williams and a lot of these other comedians, and it's gonna go crazy. But let me get to the content real quick and knock a 10 in this thing because it's gonna be a while.
Okay.
All right. So it recount acts entirely unattributable to Mr. Knight, the alleged illegal airing of that video by TMZ and TMZ's labeling of an object in the video as a possible gun. It includes a press conference during which Mr. Knight's then attorney, Matthew Fletcher, claimed petitioner was attacked by gang members, including one with a handgun. ID. It refers to the indictment and conviction of two of Mr. Knight's counsel, Matthew Fletcher and Thaddeus Culpepper, on charges of witness tampering. There is no evidence Mr. Knight had any responsibility for or involvement in the actions of Ms. Kelly, Mark Blankenship, TMZ, the addition of a label by TMZ, Fletcher, or Culpepper. If there had been, he would have been charged. The prosecution further states that Mr. Knight's visiting and phone privileges were restricted after Fletcher and Culpepper were indicted. This is not accurate. On March 17, 2015, Judge Cohen terminated Mr. Knight's visiting, mail, and phone privileges for so long as he remained in custody or until further court order. On February 3, 2016, Judge William Ryan granted the prosecutor's request for permission to listen to his telephone calls to any person other than his attorney of record or any investigator retained by his attorney, as well any three-way calls with his attorney. And in July 2016, the court ruled that this order was retroactive to February 1st, 2015. It was not until January 24, 2018 that sealed indictments against Fletcher and Culpepper were returned. And those indictments were not made public until March 15, 2018, more than 3 years after the March 17, 2015 order terminating privileges. The statement by respondent that Mr. Knight privileges were restricted after the indictment of Fletcher and Culpepper is simply untrue. In fact, he lost his jail privileges years before the indictments. Respondent's description of Mr. Knight's conditions of confinement as merely restricted in formal response is an extraordinary understatement. In fact, Mr. Knight lost all visiting privileges, telephone privileges, and the ability to receive and send mail, except with respect to counsel of record. Respondent's assertion that he was allowed unrestricted access to the attorney of record and any potential new attorney of record is untrue. In fact, a person in jail cannot contact a potential new attorney without the ability to make phone calls or write a letter requesting a visit. Nor can a person allow no contact with anyone but his attorney of record make arrangements for payment of counsel. So basically what they're saying is, because of these restrictions, how can y'all expect a blind man that's incarcerated with no access to utilize the phone, can't get visits from nobody except the attorney that we do got, and he fighting a civil case, and y'all still hold me accountable to the time limits and constraints to even file this habeas corpus. But he's making a hell of a case. In addition, the court, the prosecution, the Los Angeles County Council, and the judge vetted prospective counsel seeking to visit Mr. Knight. Some counsel seeking a visit were denied because prosecution objected. Others were allowed a visit, but only if they consented to that visit being tape recorded, a violation of attorney-client privilege to which no ethical, competent lawyer could agree. Facts.
Right.
Other counsel who were successful in receiving court-ordered visits were arbitrarily denied visitation after Los Angeles Sheriff Department jail personnel consulted with the Los Angeles Sheriff Department investigating officers assigned to this case and were told not to honor the court order for visitation. Exhibit 4 at page 104. Ooh, David Kenner got receipts. The sheriffs was still denying the court order. This is nasty work. For example, on April 21st, 2016, Mr. Knight thanked Judge Cohen for giving him the rights to be able to at least call my attorneys to fight my case so I could be ready for trial, because that's what I want to do, prove my innocence. But he then told the court that this right was subject to approval by Sergeant Biddle. So they quoted, this is from the transcripts. So then I asked to use the phone one time. It was a deputy by the name of Jack Quez. Jack Quez said, well, you got the court order, but now I got to call my boss. I said, who is your boss? He said, Detective Biddle. He went and called Detective Biddle on his cell phone and says, I want to call my attorneys. It's 2 attorneys on record they allow me to call. So I asked Deputy Jack Quez. I said, look, officer, sir. I said, you supposed to work for the county jail. Why? When did Detective Biddle become your boss? He said, when it comes to you, it is. That's why I'm supposed to call him. And so they didn't let me call at first. Exhibit 4 at page 104. So David Kenner is showing the history of these people restricting his access to the courts, which is a constitutional right for any inmate to litigate so that they could present a reasonable defense against any allegations they're charged with. So they got all of the other exhibits down on the next page. Boom. Respondent lists 15 attorneys who entered appearances for Mr. Knight and other attorneys who obtained a court order allowing a jail visit with Mr. Knight as proof that he had fair and full access to representation throughout the pendency of his case, and go so far as to state that an allegation that he did not is both patently false and intentional misleading to this court. In formal response at page 8, 9 through 15. In fact, the conditions of Mr. Knight's confinement were such that nothing could be further from the truth. Until the day he was sentenced, he was held virtually incommunicado, except for his attorneys of record, most of whom he wanted to replace. He was denied the means to identify, communicate with, interview, and retain competent representation in this case. Damn.
So both said damn at the same time.
Yeah, you fighting for your life. Everybody who don't know the situation, he caught a case at the Straight Outta Compton movie shoot in front of Tam Burgers. If you look at, that's why I had the Tam Burgers in the background of his jail picture on the thumbnail. And he was allegedly approached by some guys. He obviously feared for his life, jumped in his blazer and was trying to pull off. And he hit Terry Carter and Cleveland Bone. Now, Bone, while we on this topic, I'm hoping that you doing the right thing and trying to get this man off. Because if you don't know about Damu Kiwe Conversations, we will flame your motherfucking ass up, and I got the work. You know what I'm saying? And if I say I got the work, you best believe the whole team will be flaming your ass up, and everybody gonna know what you did and what you didn't do. Right. You know what I'm saying? But I got it in the votes. Nigga, don't make me have to do this. You know what I'm saying? But yeah, he's so fighting for his life. He ended up running over one of his close friends, Terry Carter, OG Westside Paru, OG Paru Street, also had Heavyweight Records, which at one time put together shows with Ice Cube, Westside Connection, Mac 10, all kind of other different artists. And that was a friend of his. That was obviously an accident, which shows you how afraid he was and was trying to get out of there with his life. You know what I'm saying? So let me get back to the thing. But while he's fighting for his life and his freedom, they restricted him like that. He want to fire his attorneys. They won't even allow him to talk to other attorneys that he believed might have his best interest, because obviously these attorneys weren't talking about it. And I'm quite sure this might have weighed into his mind on taking that 20-something year deal he took. Because I was like, man, that's a manslaughter. Obviously, involuntary. He didn't intend to unalive Terry Carter, right? So he trying to get up out of there. That happened. I mean, what he gonna get? 7 years, 11 years? Involuntary manslaughter might get you 2, 3, 4 years, right? And when he took 28 years, it threw me off. You know what I'm saying? But his lawyers at the time were caught up with allegedly tampering with witnesses or something else and were later convicted. So I could see why he was trying to distance himself away from them and find other attorneys, and he was restricted in jail, wasn't able to call his no other family. So if he didn't have no family members who knew how to and were fighting to assist him, he was up in there by himself, you know what I'm saying, facing these allegations without a proper defense. That's a sad story, from a mogul to that. But let me get to this. Mr. Knight is entitled to the issuance of an order to show cause and an evidentiary hearing. A, petitioner has met the pleading requirements for a habeas corpus petition and has stated a prima facie case for relief. Respondent asserts that habeas corpus relief is an extraordinary and limited remedy against a judgment that is presumed valid, and it is not available to all persons in all situations. Informal response at page 16. However, at this point, the issue is not whether Mr. Knight is entitled to relief. Petitioner's burden at this stage is to plead sufficient grounds for relief. People versus Duval 9 Cal 4th, and they cite the case. It is only after an order to show cause is issued that a petitioner has the burden to prove his allegations. The question before the court is whether a prima facie case has been made. To answer this question, the court asks whether, assuming the petition's factual allegations are true, the petitioner would be entitled to relief. ID at 475, emphasis added, when the factual allegations, if true, would entitle a petitioner to relief, he is entitled to the issuance of an order to show cause why the requested relief should not be granted. Here's another keynote, a footnote. Footnote number 6, to be exact. It is worth noting the information provided by respondent about attorney visits to Mr. Knight does not include any visits by Albert DeBlanc. Hereinafter, DeBlanc, who respondent describes as having been appointed to ensure petitioner would have competent counsel for the approaching jury trial. As will be demonstrated, DeBlanc did not provide competent representation. Now back to page 8. Mr. Knight habeas corpus petition contains facts pled with sufficient particularity, which, if proved at a hearing or not disputed by the prosecution, would entitle him to relief. Respondent has offered no grounds to justify denial of the petition at this stage of the proceedings, and an order to show cause should issue. The informal briefing process of Rule 60 of the California Rules of Court is designed to assist the court in determining the petition's sufficiency. People versus Romero. It acts as a screening function to weed out claims that are procedurally barred or whose factual falsity can be easily shown without the necessity of issuing an order to show cause. An informal response is not a pleading, does not frame or join the issues, and does not establish a cause in which a court may grant relief. ID at 741. Accordingly, the informal briefing procedure does not require a petitioner to fully develop the factual basis of his claims and prove violations of his state and federal constitutional rights as contemplated by the right to habeas corpus guaranteed by Penal Code subsection 1473 and recognized by the California Constitution to be absolute, Cal Constitution, Articles 1, subsections 11. The informal response purports to challenge the factual basis for Mr. Knight's claims, but beyond bald assertions that the claims do not merit relief, offers negligible factual or legal support for his position. Any dispute of fact critical to the outcome of the petition is to be determined by this court. After the issuance of an order to show cause, which will give petitioner the right to use the court's compulsory process and subpoena power to obtain discovery and to prove his claims at an evidentiary hearing. People versus Romero, they cite him again. In conclusion, Mr. Knight has stated a prima facie case for his claims, and he is therefore entitled to the issuance of an order to show cause. A denial of the petition without an order to show cause would arbitrarily deny him his state law right to California's habeas corpus procedure and to the full and fair factual development of his claims in violation of the state constitution and the 5th, 6th, and 14th Amendments to the United States Constitution. People versus Bartone, 21 Cal 3D, Hicks versus Oklahoma. B, the petition is timely. Let me wet my whistle a little bit with a little bit of this.
Yeah, because you get a little hoarse over there. Mm-hmm.
Hennessy.
I'm not sipping tonight. I'm behaving.
Look, you gotta be. It's 2025. That Hennessy make life just that more live. Whew. Is Yael still with us or did he drop out?
Huh?
Oh, Yael, you got
Damu Kiwe Conversations.
Nah, brother, you ain't even greeted the queen, brother. You out of pocket, brother.
Man, how you doing, Henny? How you doing, sis? Where the Hennessy at?
The Hennessy is on the shelf. Thank you.
Oh, yeah.
But look, Yael, I think, my apologies, but it looks like I'm taking your job as being the new pop star of the broadcast.
You can never be the Kiwe pop star, baby. You got to be sis.
I didn't say the Kiwe pop star. I just said the pop star. See?
You got to hit a note to be the pop star. Let me hear the note. Nah, you didn't make the cut. Drink some more Hennessy. You'll be all right.
He like, my spot is safe. I know how to say.
Look, yes.
Hey, Yael, just hit a note like the Kiwe pop star can. Just one good note. You know what I'm saying? Let's get one.
Be like, she said,
Listen, I never proclaimed myself to be a singer, okay?
I will be giving out singing lessons. Tap into OTGIL for the Kiwe pop star singing lessons. Henny, you will be my first student. Don't worry about it.
Ain't no helping me. I could guarantee that. Let's get to it though. So, the petition is timely. Respondent alleges Mr. Knight's petition is untimely because all the facts listed in the petition were known to the petitioner at the time of sentencing. On October 4th, 2018, informal response at 18. This argument is without merit. 1, the assessment of timeliness. In non-capital cases, the court is required to consider the timeliness of a habeas corpus petition without imposing fixed, determinate deadlines. Robinson versus Lewis. Whether a claim has been timely presented is assessed based on an indeterminate reasonableness standard. I.B. There is a 3-level analysis for assessing whether claims in a habeas corpus petition have been timely filed. First, the claim must have been presented without substantial delay. Robinson versus Lewis. This requirement has also been described as promptly as the circumstances allow, citing Henry Clark, right? And in Reno, 2012 case, without substantial delay and as promptly as the circumstances allow, are equivalent terms. Robinson versus Lewis. Substantial delay is measured from the time petitioner knew or should have known of the information supporting the legal basis of the claim. So basically, they're giving you precedent laws on what governs whether what the court are to be considering in delays when it comes to filing your habeas corpus petition. Even if a claim is raised after a substantial delay, it will be considered on the merits if the petitioner demonstrates good cause for the delay. Robinson versus Lewis. If there is a substantial delay and there is no demonstration of good cause for the delay, a claim will nevertheless be considered on the merits if it falls within one of three exceptions. 1, error of constitutional magnitude led to a trial that was so fundamentally unfair and that absent the error, no reasonable judge or jury would have convicted the petitioner. 2, petitioner is actually innocent of the crime of which he was convicted. Or 3, petitioner was convicted and sentenced under an invalid statute. So that's basically what they have to establish happened, 1, 2, or 3, so that he could get a new hearing. In addition, although an individual error may not arise to the level of a prejudicial constitutional violation, when considered cumulatively, individual errors can amount to a denial of a petitioner's constitutional rights. See Akala versus Woodford, Parley versus Runnels. Stated differently, constitutional errors that are not prejudicial by themselves may be prejudicial when considered cumulatively. See Alcala versus Woodford, and they cite the case number, and then Killian versus Poole. Finally, while ordinarily habeas corpus is not a substitute for appeal, court has discretion to issue the writ if it believes an appeal is not adequate or if a prompt disposition is required in the interest of justice. In Reed Duran, 30 Cal, and they cite the case. 2, Mr. Knight's petition was timely filed. Mr. Knight was sentenced on October 4th, 2018. He was subsequently transferred to Wasco State Prison Reception Center in Kern County, where he was held in administrative segregation for processing, classification, and physical and mental evaluation to determine his security level, program requirements, and appropriate institutional placement. In approximately mid-November 2018, he arrived at Richard J. Donovan Correctional Facility, Donovan, in San Diego, located 1.5 miles from the border of the United States and Mexico. Once at Donovan, Mr. Knight again held in administrative segregation for a time, pending a decision on where should he be housed. Once Mr. Knight was assigned permanent housing at Donovan, he was able to contact Albert DeBlanc regarding the status of the appeal in this case. Because he told DeBlanc he wanted to appeal, and DeBlanc said he would file an appeal on his behalf, Exhibit 57, so he has proof of that. There was no response from DeBlanc. In late April 2015, petitioner received a copy of an order by the Court of Appeal dismissing his appeal as untimely. So now DeBlanc is ineffective because he didn't file the appeal, and this is what he already told him he wanted to do. As representation of him, he was supposed to do it. Starting to sound like the fix was in. They railroaded him in court, made him feel the pressure, take a 28-year deal with appeal rights. He wanted to appeal. He get reception. You get 0 phone calls in reception. 0, right? Then from there, he goes to administrative segregation, and when he get in Donovan, and then so he doesn't have access like the rest of the inmates in general population. He's essentially in the hole, right? But he's not in the hole for disciplinary. He's in the hole because the administration have segregated him while they decide how to house him because of his mental health. They said his physical health and also security concerns as his crime, him being a high profile celebrity, etc. Right? So he's counting on his attorney to do the appeal, and his attorney left him for dead. In late April 2015, petitioner received a copy of an order from the Court of Appeal dismissing his appeal as untimely. Thereafter, Mr. Knight asked DeBlanc to send him his file in his case so he could pursue available relief, but DeBlanc never did so. Exhibit 7. So he got proof that he was telling this lawyer that represented him that what to send him the stuff so he could do this, and the lawyer abandoned him, right? He's not advocating on his behalf. He subsequently asked DeBlanc to transfer his file in this case to attorney Dermot D. Givens, but DeBlanc failed to do so. Exhibit 56. Mr. Givens was able to obtain some court records in this case, but he had to wait months to be approved to visit Mr. Knight at Donovan. See Exhibit 7. Mr. Knight's vision is severely impaired. He is totally blind in his left eye due to chronic glaucoma. He has only 15% vision in his right eye caused by glaucoma and diabetic retinopathy. I did hear through Reggie Wright Jr. and I think Big U were telling me about his bad eyesight, and I know how bad of a diabetic he was even on the street, right? So as a result, he has significant difficulty reading any records he received. His writing ability is also affected by his impaired vision. In addition, in January 2020, the COVID-19 virus was first detected in the United States. On March 4th, 2020, a state of emergency was declared in California, and a mandatory statewide stay-at-home order was issued. On March 11, 2020, the California Department of Rehabilitation and Corrections, CDCR, canceled normal visiting throughout the state and prisons. Like the rest of the population, went on lockdown. Because of these restrictions, a prisoner's contact with the outside was limited, as was movement within the prison, including access to the law library. It was not until July 11, 2022, more than 2 years later, that the CDCR announced its roadmap to reopening from COVID restrictions, which initiated a gradual relaxation of conditions. On May 26, 2022, while COVID restrictions were still in place, a civil trial commenced in the Los Angeles Superior Court in Lillian Carter, inter alia versus Universal Studios, Inc., inter alia, number BC58. Hey, Henny, we need to pull that case up. The sole defendant who went to trial was Mr. Knight, Exhibit 10 at page 1. On June 25th, 2022, after days of deliberations and 26 notes from the jury, the last of which reported a deadlock on battery and negligence, 7-5 now. The judge declared a mistrial because the deadlock has now deteriorated from 8-4 to 7-5. Exhibit 11 at page 9, 10, and 12. Mr. Knight's in pro per Habeas Corpus petition was served by mail on March 14, 2023, 8 months and 17 days after the mistrial in the civil case. Given the fact that Mr. Knight was incarcerated, has no legal training, had limited access to law library, suffers from severe vision problems that affect his ability to read, and the restrictions imposed on his conditions of confinement due to COVID, the writ was filed as soon as practicable after the mistrial in the civil case. The fact that Mr. Knight habeas petition includes claims about events that occurred before the mistrial in the civil case does not mean that those claims are untimely. The successiveness bar prevents a habeas corpus petitioner from abusing the writ process by presenting claims in a repetitive or piecemeal manner. See Henry Horowitz, Henry Friend, and then bam. The civil lawsuit was based on the same events that gave rise to Mr. Knight's criminal conviction and had not yet been tried at the time Mr. Knight was sentenced. Therefore, he could reasonably wait until he was able to include the results of the civil case in his petition. This course of action is consistent with habeas corpus jurisprudence. Mr. Knight was not required to file a petition before the civil matter concluded. If he had done so, respondent would have invoked the successiveness bar and alleged that a second petition based on a civil trial should be dismissed because it was not timely and abuse of the writ. Footnote 10. The civil case is still pending. Retrial is scheduled to begin on April 7, 2025 in Department 48 at Stanley Mosque Courthouse. We'll definitely try to keep y'all abreast what goes on with that civil case on Suge Knight. The doc in this case reflects that the petition for writ of habeas corpus was not received until April 10, 2023. In assessing timeliness, it is fair to consider the time respondent needed to file its informal response to Mr. Knight's petition. On May 1st, 2023, the court ordered respondent to file an informal response within 60 days. The informal response was not filed until February 5th, 2024, more than 9 months after it was ordered. 2 months later, on April 5th, 2024, respondent requested and was granted leave to file an amended informal response, which was filed July 8, 2024. Petitioner, an incarcerated lay person with no legal training, limited access to the law library, and impaired vision, filed his habeas corpus petition within less time than responded. An experienced lawyer with no apparent vision problem and ready access to the law library needed to prepare and file the informal response and amended informal response. 4. Mr. Knight's claim for relief. Claim 1. Denial of request for recall, modification of sentence. So he's asking for modification of his sentence. Petitioner submits this claim on the pleadings. B. Claim 2. Violation of petitioner's right to self-representation. Mr. Knight was denied his right to self-representation under Ferretta versus California. Okay, the Ferretta motion. So here we go right here. So then you got 1, March 2nd, 2015, Ferretta motion, statement of facts. On March 2nd, 2015, when this case was called before Honorable James R. Bradlin in Department 500, defense counsel announced their appearance and Mr. Knight interjected, "Excuse me, Your Honor, I'd like to speak, please." Exhibit 12 at page 1 through 2. The court replied, "One moment, please, just one moment. Go ahead and finish your appearances, please." Thereafter, the court asked counsel why Mr. Knight wished to address the court, and Mr. Knight stated, "Well, I want to address the court, Your Honor, because at this time, I don't know if I can move forward because I got to hire counsel. There's 2 things I want to bring up is, number 1 was my health. Since I've been here, I lost about 35 pounds, sent to the hospital several times. I'm 100% blind in one eye, don't even reflex the light. They sent me to the hospital because one physician said they couldn't find anything wrong. They sent me to the hospital. Now I have about 15% in my good eye. Dr. Pam Phonetic, who is a great doctor, Dr. Barry, it was Boston, checked it. I was also shot 6 times. I've been having this. I had a blood clot in my lungs where I had problems. Like I said, I lost about 35 pounds. I can't really see. Sometimes I can't comprehend what's going on at some point. And at this point, the court said, Mr. Knight, and petitioner responded, I also want to put on the record, excuse me, sir. He was then told not to interrupt the court and responded, oh, I'm not trying to interrupt you. The court then stated, if you want to hire different counsel, you're welcome to do so. If you want your lawyers to address issues regarding your medical treatment in the jail with the court, I'm happy to address those issues. But you are here for a very limited purpose today. It deals primarily where your case is going to be assigned. So for our purposes today, I'm going to address that issue, and then the judge that the case is assigned to is going to handle all other issues related to your case. Mr. Knight responded, okay, I don't have a counsel to address the issue. The court told him that counsel is standing right next to you. Mr. Knight stated, he's not my lawyer. The court told Mr. Knight, he is your lawyer. You hired him. You retained him. In response, Mr. Knight stated, you didn't retain him. I did. And I fired these attorneys before. At this point, the court told Mr. Knight, don't speak, and asked counsel if there was an issue with the media. Mr. Knight stated, I can't speak. I can't. And the court said no. Mr. Knight said, I can't get medical treatment. And the court said he would address that with Mr. Knight and his lawyer, but he was not to interrupt him. Thereafter, oh yeah, the railroad is going down. Media coverage was authorized. Let me finish this section, Henny. I want you to take over so I can get, But thereafter, media coverage was authorized over objection. The case was transferred to the Central District of Los Angeles and assigned to Judge Cohen in Department 101 for all purposes. Mr. Knight persisted, telling the court, I'd ask to go pro per if I have no counsel, and I'd ask to address the court. The court's response was to order the matter transferred forthwith to Department 101. Mr. Knight did not appear in Department 101 on March 2nd, 2015, Exhibit 13 at page 1. Defense counsel immediately informed the court that Mr. Knight wanted other counsel and asked the court to keep everything status quo. This did not happen as the case had already been transferred to Judge Cohen, who scheduled a discovery hearing on March 9th, 2015. On that date, Matthew Fletcher appeared with Mr. Knight and substituted in as counsel. See Exhibit 14. The Sixth Amendment right to counsel guarantees a defendant's right to proceed to trial without counsel when he voluntarily and intelligently chooses to do so. Ferretta versus California. A request for self-representation must be unequivocal and timely and must not be a tactic to secure delay. If these criteria are met, then the defendant's motion to represent himself should be granted. I think they should. He made a hell of an argument. They supposed to grant it that. You know what I'm saying? That they might have violated his Constitution, Sixth Amendment constitutional right, and that's guaranteed by the U.S. Constitution. On March 2nd, 2015, Mr. Knight made unequivocal, timely requests to represent himself. At the outset of the hearing, he told the court that he needed to hire counsel. Exhibit 12 at page 3. He said that he did not have counsel to address the issue of the reassignment of his case and clearly informed the court that the attorneys present in the court were not his lawyers. ID at 3. When the court told him that he had counsel, you hired him, you retained him, Mr. Knight's unequivocal response was that he had fired the attorneys. He repeatedly tried to address the court in a respectful manner, but was not allowed to speak. He stated that he had no counsel and made an unequivocal request to represent himself. I'd asked to go pro per. ID at 6. This request should have prompted action by the court. Instead, it was ignored. What he should have yelled when they kept ignoring him was Marsden, because they're typing. And as long as you're yelling Marsden, that's telling the court that you want to have a Marsden hearing, right? But he's a lay litigator. He might not even knew that, but because he didn't know that, ignorance of the law is no excuse. They railroaded him. You know what I'm saying? But it sounded like he got action though. This motion was timely. It was made at the beginning stage of this case, which is plainly a reasonable time before trial. People versus Mayfield. Henny, this is starting page 16. Could you assist me, please? Give me
All right.
break.
Mr. Knight's request to represent himself was consistent with his conduct and other statements he made in the court that day. The court's failure to acknowledge Mr. Knight's clear desire to represent himself, to make appropriate inquiries regarding his request, and to grant the request is irreversible error per se. The formal response does not address Mr. Knight's FREDA claims, which cites the proceedings before Judge Branlin on March 2nd, 2015, is supported by a transcript of the hearing. Instead, respondent refers to events that occurred almost 3 years after the hearing, March 2nd, 2015. Respondent references a hearing on November 14th of 2017 before Judge Cohen and asserts that petitioner did not object to standby counsel. Informal response at 29. First, the absence of an objection to DeBlanc's appointment years after Judge Brayland ignored Mr. Knight's request to represent himself has no relevance to the present issue. Second, when he appointed DeBlanc, Judge Cohen instructed Mr. Knight that he could not be fired by you. Okay, Exhibit 14, page 128, emphasis added. Respondent also refers to November 14th, 2017 hearing, which is described as interesting because Knight had previously fired Mr. Culpepper from his homicide case, but he kept him as attorney of record for the robbery case. Okay, and that's the case number and a clear example of petitioner's hearing and firing attorneys on his many open cases. Informal response at page 31. However, these events are irrelevant to March 2nd, 2015. They messed up there. When Judge Brayland would not hear Mr. Knight's FREDA motion. The same is true as the respondent's reference to Culpepper's return to this case on February 1st, 2018, and his subsequent removal as counsel due to his indictment for witness tampering. Remember, so Culpepper was witness tampering, or
let me see. It was with removal as counsel due to his indictment for witness tampering.
So the counselor was witness tampering.
Facts. The lawyer.
The lawyer. Yeah.
Hey, they got charged, but I'll let you finish. But yeah, they got charged.
These events have no relevance to what occurred in Judge Brayland's courtroom. Now, there is a reference down here to 12. Claim 2 of Mr. McKnight's Habeas Corpus petition incorporates by reference his motion to recuse and the exhibits there too. Habeas Corpus at page 5B. Finally, Ms. Bano's March 23rd, 2008 removal from representing Mr. Knight based on a conflict of interest, which participated in DeBland's elevation from stand by counsel to counsel of record, is not relevant to the FREDA claims. Respondent describes the statement that Mr. Knight was denied the opportunity to hire his own attorneys as ridiculous. Informal response at page 36. As will be demonstrated, Knight's inability to identify and retain competent counsel was a direct result of his conditions from confinement in Los Angeles County Jail, conditions imposed by the court, respondent, county council, and the Los Angeles County Sheriff's Department. He was able to make phone calls from the jail, unable to send letters to attorneys seeking their representation, unable to receive incoming mail, and unable to receive visits from attorneys who were not counsel of record without a court order. These restrictions rendered him unable to find and retain competent counsel. 2. April 8th, 2015, FREDA request. Mr. Knight appeared at Judge Cohen's court on April 8th, 2015 in, that's the case number, the camera snatching case. After confirming that Mr. Kenner no longer represented him in that case, Mr. Knight asked to represent himself. until he found a representation. The judge said no, thanked him for asking, then declared, "We're done." Deputies then cleared the courtroom. Damn, they wouldn't even let him represent himself.
Yeah.
Judge Cohen's failure to conduct the inquiry required by FREDA and peremptory denial of Mr. Knight's request to represent himself was error, as demonstrated by the events in Judge Braylon's court and a subsequent hearing before Judge Cohen discussed below. It was part of a pattern of improper summary denials of unequivocal requests for self-representation, a pattern that could only convince Mr. Knight that any such request would be futile. March 23rd, 2018, FREDA request. The transcript of the April 8th, 2015 proceedings had been ordered but not yet received. This hearing began with Judge Cohen stating that while waiting for counsel, there was an in-camera hearing with Ms. Banos. As a result, he found a conflict of interest and was granting her motion to be relieved. Exhibit 17 at page 162. Mr. Knight then addressed the court regarding this case, his conditions of confinement, and his previous counsel. He stated in relevant part as follows: "But the most important thing is this. Should I have the right to use my money where I want to? Oh, I should have the right to use my money where I want to. And been complaining about this over and over again. Like I said before, I haven't seen no discovery. I haven't seen none of the stuff that any other person fighting their case should have a right to have knowledge of." And that's ID at page 166. Mr. Knight's next informed the court that he was also trying to replace court-appointed investigator John Moore because he had contacted the mother of his child trying to borrow money. ID page 167. He said there was an attorney flying in to see him that week, and "I want to have somebody to represent me right away, Your Honor." Mr. Knight concluded his statement to the court by saying, "Once and for all, you guys got to give me a fair chance to represent myself." ID at page 169, emphasis added. The court's response was, "All right, at this time, I'm appointing Mr. Albert DeBlanc as attorney of record on both cases. Mr. DeBlanc is present." Mr. Knight's response was, "So you telling me I can't have my attorney I paid my money for?" The court said, "I didn't say that. Right now, DeBlanc is representing you. Now he is your attorney of record." ID at PP 6 pages 169 through 170. When Mr. Knight asked for a fair chance to represent himself, he was invoking his right to self-representation under FREDA versus California. This was not his first request to represent himself. His prior requests for self-representation are consistent with this invocation of his FREDA right. This request is unequivocal. See People versus Carlisle, 86. Okay. It was made a reasonable time before trial. Mr. DeBlanc had just been appointed and there was no trial date set. See Exhibit 17 at page 173. Mr. Knight's timely request for self-representation was erroneously denied. This is a reversible error. Claim 3, sentencing Mr. Knight on prior strikes. Petitioner submits this claim on the pleadings. D, Claim 4, denial of Mr. Knight's right to counsel of his choice. 1, introduction. Respondent's 5 line response to his claim is that petitioner hired and fired 14 different lawyers. Only the 14th attorney, Mr. DeBlanc, was court appointed, and that was done with the consent of the petitioner. Informal response at 42, emphasis at original. First, the statement that Mr. Knight consented to representation by DeBlanc is not true. In fact, DeBlanc was forced on Mr. Knight, who was told by Judge Cohen that he could fire DeBlanc. Second, respondent fails to address the crux of his claim, i.e., the severe unconstitutional restraints on Mr. Knight's ability to communicate with attorneys and the outside world that were imposed by the court, which effectively abridged his right to counsel of his choice. 2. Statements of relevant facts. On November 7th, 2017, Mr. Knight relieved Jerry Leesman as his attorney, leaving Ms. Banos as his counsel. Based on what the court described as Mr. Knight's history of relieving multiple defense counsel, it announced its intent to assign bar panel attorney as standby for Mr. Knight. Exhibit 2 at pages 76 through 77. At the next court appearance on November 14th, 2017, Albert DeBlanc, a bar panel attorney, was appointed as standby counsel pursuant to Penal Code subsection 987A. The court told Mr. Knight that because he fired so many lawyers that there is a trial date coming up and I can't trust what's going to go on. DeBlanc was to be like sitting on the bench. Okay. And then the footnote says this statement of facts as to this day is based on the court's minute order. A transcript of proceedings on the date has been requested but not yet received.
Not you. I'm talking to my baby. Not you. I'm talking to my baby boy. He done jumped up here with me.
Oh, okay. Big boy. Tonight continued to seek private counsel after DeBlanc's appointment as standby counsel. On November 15, 2017, Ms. Banos obtained an order for a visit by attorney Jeff Broden. On November 15, 2017, Exhibit 2, page 78. On February 1st, 2017, a motion for attorney visit to Mr. Knight by Jeffrey Friedman. Where the hell are all of these attorneys coming from?
They trying to get that money. Yeah.
Like, what the hell? Was granted. Exhibit 2, page 83. On February 13th, 2018, an attorney visit with Jose Baez was granted. Exhibit 2, page 84. On February 21st, 2018, Jeffrey Friedman was granted one visit to petitioner. Exhibit 2, page 87. On March 1st, 2018, Jeremy Friedman was also allowed one visit. Exhibit 2, page 87. After the removal of attorneys Culpepper and Banos, which is Culpepper is on Exhibit 2, pages 89 through 90, and Banos is Exhibit 17, page 162. Based on conflicts of interest, DeBlanc was appointed to represent Mr. Knight in this case, which is the case number. The trial date of April 30th, 2018 was advanced and vacated. The matter continued to April 23rd, 2018 for pretrial trial readiness conference. Exhibit 2 at pages 93 through 95. Mr. Knight continued his efforts to retain counsel after DeBlanc's designation as attorney of record. After allowing a visit by attorney Richard Schoenfield, that's how you say that, right? Schoenfield?
Yes.
Were signed on April 4th, 2018 and May 2nd, 2018. Exhibits 2 at page 96 through 9.
Yeah.
Cassell obtained orders for a visit with Mr. Knight on May 22nd and June 7th of 2018. In addition, additional order for a visit by Jeremy Friedman was signed on April 20th, 2018, Exhibit 2, page 96. Attorney Alex Kessel was granted an additional attorney visit on May 23rd of 2018 and June 7th, 2018, Exhibit 2 at page 98. An order permitting a visit by attorney Richard L. Johnson was granted on September 10th, 2018, Exhibit 2, page 109. God damn, is there another one? Will there be another? Even after Mr. Knight entered a plea of no contest on September 20th of 2018, he still tried to contact other counsel. So the footnote for this one says the minute order described this lawyer as Jeremy Friedman's email address. State bar records show his true name is Jeremy Martin Friedman. All right. So, however, because the district attorney objected, there were no action. There was no action on the second motion for a visit by attorney Richard L. Johnson, filed September 20th, 2018, Exhibit 2, page 107. The third request for a visit by Richard L. Johnson, filed on September 25th, 2018, was not granted because the district attorney, quote unquote, continues to object. Exhibit 2, page 107 through 106. Through 06. Mr. Knight was sentenced on October 4th, 2018, 8 days after the court failed to act on Johnson's second request for attorney visit for Mr. Knight. 3. Mr. Knight was unable to retain counsel of his choice because of conditions of his confinement. A. Proceedings on February 1st, 2018. On February 1st, 2018, Mr. Knight plainly invoked his right to counsel of his choice and informed the court that the conditions of his confinement prevented him from retaining counsel. Well, Your Honor, as you know, Your Honor, I've been here 3 years served, and at the same time, I'm not. I can't have no outgoing mail, no incoming mail, no visits, no nothing. So as for me to hire attorneys and say fire attorneys, that's the part I've been going through. And when I do get counsel to come and see me, they don't approve. And the counsel I have on record, their number has been blocked for 2 years. So there's no communication. So there is no way that's what I'm trying to speak to you about. I have asked to see Judge Ryan 1,000 times, like you asked me. When Kenner and the other people requested me to be here, he never allows me into the courtroom. So if you my judge for the trial and he's supposed to be for all purpose, I'm supposed to see Judge Ryan. And you can check the paperwork. Judge Ryan never allows me to be in there. That's when the other attorney go there and tell him they want me to be present. He say no. Actually, Your Honor, the problem I have is this. They have my PIN number blocked where I can't call none of my attorneys on record. I can't have no outgoing mail, no incoming mail. Exhibit 19, pages 132 to 34. The court did not respond to Mr. Knight's statement. Instead, there was a query about Culpepper's conflict of interest. Judge Cohen offered to appoint an attorney to advise Mr. Knight about potential conflicts with Culpepper. Mr. Knight's response was, I want to have my right to pay and have my own attorney. ID pages 137 through 141, emphasis added. Judge Cohen told Mr. Knight that he can hire any lawyer he wants to represent him. And Mr. Knight's responded, that's what I've been trying to do. ID page 142. The discussion continues, and Mr. Knight again states that he wants to see the attorney that he's trying to see to do my case. I want to be able to talk to them. ID page 143. The court's response was, I'm not concerned about that. That's a different issue. I want you. You say you want to waive talking to an independent attorney relating to any conflict or not. Mr. Knight's response is, I want to talk to my own attorney, not to you guys' attorney. ID at pages 144 through 45, emphasis added. At this point, Mr. Knight consulted with Ms. Banos, waived
consultation.
Consultation, thank you. With another attorney, ID page 144 through 45. The court began to take a waiver of Mr. Knight's rights to consult with another counsel and to conflict-free representation, during which Mr. Knight states, I choose to pay for my own attorney. ID at 144 through 45, emphasis added. See also page 46, the same. He then returns to his difficulty in communicating with an attorney to hire. And in jail, it's not allowing, even when they get court orders, they are not allowing this. They are not allowing these. attorneys to see me. So it's a problem because if I can't talk to an attorney, I can't hire an attorney. ID page 147, emphasis added. During the court's advisement on the potential conflict in Culpepper representing him, Mr. Knight states, what I'm not understanding is if the people are not allowing me to, the court, this has nothing to do with the people. Mr. Knight, yes, it does. ID at page 149. Mr. Knight continues, what I'm trying to say is that they're not allowing me to hire the attorney who's been trying to see me that I've been containing. ID page 149 through 50, emphasis added. At the conclusion of the proceedings, Mr. Knight once again refers to restrictions on his ability to interview counsel. Mr. Knight, Your Honor, could I also make sure I'm able to see attorneys I want to hire? Because as to, there's no respect to them. The court, I understand. Mr. Knight, he hands her the papers. She slams them to the floor. There's no way I could get it. Damn. The court, Miss Bonos, you take care of that in Judge Ryan's court. Miss Bonos, yes, sir. ID at 55, emphasis added.
Damn.
This is...
They done took every right that this man has, right? Mm-hmm. And he's already incarcerated, and he's trying to fight to put on a reasonable defense against the allegations, and they're just putting roadblocks and roadblocks and roadblocks to prevent him from positioning himself to even have a chance at being proving his innocence in trial. Now I see why he took the 28 years.
I've never heard of anything like this before in my life.
Now it happens. They gagged him. They put him on a gag order where he couldn't talk at court. He already ain't got no phone calls, and then you got CS2 back out here kicking his back in while he down. Right. This dude is blind in one eye, got 15% vision in another, dealing with diabetic issues. He's facing all of this time. This is sad. And the court and the justice system obviously done felt this man.
Big time.
Yeah, let's get through this. I get about like 5 more pages and I'll take over. Give you a break.
All right. Proceedings on March 23rd of 2018. On March 23rd, 2018, after Ms. Bonos was released, there was a conqui. Am I saying that right?
I think it's colloquy, but I ain't. Yeah, but I'm not sure. So
whatever you said, we gonna go with that.
Colloquy.
But counsel for Mr. Knight, the court said nothing, and then says, "This is the 15th lawyer that has now been taken off, Mr. Knight. I know the reason why I need to speak, Your Honor, please, because I've been trying to have different attorneys. What we got to realize here, in my case, 3 weeks in, 30 days in, I was in CCB. They took my phone privileges, my outgoing mail, my incoming mail, and no visits. And then even when you told me the first time I could hire attorneys, they never allowed me to hire attorneys. And once again, it was very important, which the court needs to understand, sir, is that each attorney I told you how those other attorneys, I meet them in the visiting room. That's a question. And I meet them in the visiting room. I meet Culpepper in the visiting room, which was not a trial attorney. I said that on record, and things he did wrong from day one. I met Fletcher in the visiting room. I meet Bonos in the Fletcher visiting room. I meet every attorney, every person I have, and this is the thing, Your Honor, I'm paying money out of my pocket. And I even said it on record before how they done stole money from my family. They stole the jewelry from my family, not Miss Bonos, but other attorneys. I complained over and over again, and each time, even when I had a right, Judge Ryan gave me the right. He said, okay, you can call your attorneys. I've never been allowed to use the phone to call my
Damn. And they told him the judge said you can use the phone to call your attorneys, and the jail is still preventing them from doing that.
That's nasty work for real.
Yeah, that's a violation of inmates' right to access the courts.
Mm-hmm.
You have that's crazy. But go ahead.
All right. So footnote: this refers to an incident earlier that day. Culpepper tried give Miss Barnes a notice of association of counsel. She declined to take anything from him, and the papers ended up on the floor. That's Exhibit 19, pages 155 through 154. All right. So he says the second thing is very important, Your Honor. I have another attorney come to get approved by Judge Ryan to come see me. When he comes to the jail, they said, "Did you get approved?" He said, "Here's my paperwork right here." And he's been practicing law a long time. They said, "Well, we don't have to honor. So we not going to honor your paperwork to see Mr. Knight." Damn, so the courts even gave them paper. And they said no. Exhibit 17 at pages 163 through 64, emphasis supplied. Turn around, the same thing with when I got Jamal Tucson. This guy, when he told the court that Jeremy Leesom told the court, when I said he was doing documentaries and DVDs and reality shows and getting the money, and they said he never would do it. Then there is the pictures and the contract to prove it. Or when Matthew Fletcher sold stuff to this person and the person for the media for money. All those hoes and stuff, all these hoes and stuff is of doing the attorneys. They just fallen on their sword. They be the ones doing wrong. Even when they knew there was an informant on the bus with me. One thing I didn't know, it was an informant. Only thing I told the guy is, hey, I can't do nothing for you. I don't have no phone calls. I don't get no mail. If you know witnesses or you witnessed anything, you got to talk to an attorney or an investigator. That's even on they could play the tape. ID at page 164 through 65. But the most important thing is this. I should have the right to use my money where I want to. And I've been complaining about this over and over again. Now I have done, and it took them this long to get approved. Have hired new counsel. I already have hired new counsel. They just been approved. They will be here this week to take over my case. And like I said before, I haven't seen no discovery. I haven't seen none of this stuff that any other person fighting their case should have a right to. ID at page 66. But every time I'm forced to use attorneys that nobody in the world would use these attorneys for nobody in the world would use these attorneys for they expect these people to do things. Well, it's not fair to me. They don't even have the right to. This was Florida attorney Jose Baez. Contrary to Mr. Knight's beliefs, Baez, he did not consider himself retained on his case. He visited Mr. Knight one time, returned to Florida, and had no further contact with him. It appears that the only information Mr. Knight received regarding the discovery in this case was from jailhouse informant Danny Timms. Damn, so he got his stuff from an informant and not even from the courts.
That is crazy.
Who was given the murder book by his handlers at the Los Angeles County Sheriff's Department and shared some of its content with Mr. Knight, Exhibit 22, pages.
So they done gave an informant his murder book. You know what's in the murder book, right? So a murder book is anytime you get booked for a murder case, it's all of the evidence, it's the pictures, it's everything. You got to wear that murder if you're convicted of it, and it's everything in that book. They gave his murder book to an informant that gave it to him. This is nasty work. The fix is in.
Yo, he's coming home. Ain't no way.
It seems like they doing everything in their power to keep them in, though. But about 2 more pages, and I'll take over.
Gotcha. All right. See proceedings on July 6, 2017. On July 6, 2017, Mr. Knight informed the court that it was difficult for him to communicate with his own counsel as well as prospective lawyers. On this occasion, he appeared in Department 101 with Jeremy Lessam. Mr. Knight told the court that the only person I'm able to call is Jeremy Lessam, and sometimes his office don't take my calls, and I have other counsel that I'm trying to deal with. Exhibit 49, page 1. He continues, I respect you and I respect your court. So I listen to you and I tell anybody to go to Judge Ryan. They go to Judge Ryan. They still don't get approved. How can I can't have one attorney for trial. I'm not trying to miss my trial date. I don't want to slow my trial date down. I know I can't. I don't want to. And I would just like to be able to talk to counsel so I can be prepared for everything I'm doing. But I am. You told me. But you told me I was allowed to have more than one attorney as long as I have one primary attorney, and that's as we speak. ID at page 1 through 2. Judge Cohen informs Mr. Knight, you can have as many attorneys as you want. His response is, but they're not allowing. They're not allowing them to see me or allowing me to communicate with them or talk to them. ID at page 2. The court ends the colloquy. I can't say that word. These matters to Judge Ryan. 4. Listen, I have a problem with. Never mind. Chronology. Thank you. Of order regarding jail privileges. The first prosecutorial. Thank you. Inclusion into the condition of Mr. Knight's confinement was on March 17, 2015, when Judge Cohen terminated Mr. Knight's ability to make outgoing calls, received and send mail, and receive visits at the jail effective March 16, 2015, at the request of Sergeant Richard Biddle. There was an exception made for attorney room visits with attorneys of record, Exhibit 21. Sergeant Biddle filed an application for a new order terminating privileges on January 14th, 2016, Exhibit 23, page 2. On January 29th, 2016, Judge William C. Ryan ordered Mr. Knight's mail, telephone, and visitation privileges terminated forthwith and revoked prior orders, gaining exceptions to the ban on visitation. The rules regarding visits from counsel of record Thaddeus Culpepper and Stephen Lewis Schwartz allowed one visit during attorney room hours only, but prohibited visits during general visiting hours without leave of court, and authorized the jail to turn away counsel who attempt to visit defendant during general visiting hours without a court order. 2. Unlimited mail to and from counsel of record. And 2. Phone calls to counsel of record with the prohibition. Thank you. Against three-way transferred or forwarded calls. Exhibit 23, page 2, lines 26 through 28, page 3, lines 1 through 12. On February 3rd, 2016, Judge Ryan granted a request by the prosecution to listen to phone calls made by Mr. Knight at any person other than his attorney of record or investigator retained by his attorney. However, if Knight called a third party who then conferenced in his attorney or investigator, the prosecution was allowed to monitor the call. And if Knight called his attorney or investigator and non-attorney is conferenced on the call, the prosecution had permission to listen to the call from the point the third party joins. Pause. Wouldn't that still be considered, if he's on the phone with the lawyer, that would still be considered attorney-client privilege, correct?
It said, and if a Mr. Knight called his attorney or investigator and a non-attorney is conferenced on the call, the prosecution had permission to listen to the call from the point the third party joins. The order further, yeah. I think that's still, they're splitting hairs just to impede upon and intrude upon any conversations he had. It's still with the attorney. For all they know, the attorney could be calling a witness.
Right.
You know what I'm saying? So, yeah, that's nasty work.
The order further authorized the monitoring and recording of conversations between Mr. Knight and any visitor, including his attorney, and any investigators returned by his attorney in the public visitation room at the jail. Exhibit 24. All right.
I'll start on page 5 after you do the footnotes.
Okay, so footnotes. On January 5th, this is 19, number 19 of the footnotes. On January 15, 2016, the supervising judge assigned responsibility for this application and all future applications regarding the condition of Mr. Knight's confinement to Judge Ryan. Exhibit 23, page 2, lines 13 through 15. 20, Judge Cohen had issued exceptions to the ban on visitors for 11 additional attorneys, 2 spiritual advisors, 5 investigators, 7 of petitioner's children, his parents, a bail bond agent, and a notary public. Exhibit 23, page 2, lines 3 to 5. The order 21, the order modified on May 31st of 2016 to permit jail visits by Mr. Knight's elderly parents. ID at page 1, line 28, pages 2, line 1 through 3.
Okay, page 5. On April 25th, 2016, then counsel Thaddeus J. Culpepper filed a motion for full restoration of Mr. Knight's phone, mail, and visitation privileges. Exhibit 2, page 33. Before the motion was heard, a notice of substitution of attorney was filed, replacing Culpepper with attorneys Jamal Toussaint, Jeremy Leesom, Antoine Williams, and Mark Leesom. Jamal Toussaint subsequently withdrew the motion for restoration of privileges, Exhibit 2, page 42 to 43. On May 12, 2016, Judge Ryan granted permission for Los Angeles Sheriff Department investigators to listen to the entirety of any recorded jail call between Mr. Knight and Matthew Fletcher on or after May 9, 2016, and to monitor and record any visit between Mr. Knight and Fletcher on or after May 9, 2016, Exhibit 25. On June 27, 2016, LA Sheriff investigators were granted permission to listen to the entirety of any recorded jail call between petitioner and Thaddeus Culpepper on or after June 10, 2016, and to monitor and record any visit between him and Culpepper after June 10, 2016, Exhibit 26. On June 29, 2016, Judge Ryan allowed visits by investigator Ken Shepard and 4 of Mr. Knight's young children, Legend, Sosa, Taz, and Balai. Exhibit 27 at page 2, lines 8 through 19. On September 1st, 2016, there was a further modification to the order terminating privileges to allow Associate Counsel Teresa Bingham to visit Mr. Knight during attorney room hours, but not during general hours without leave of court, to permit mail to and from Bingham and allowing calls to Bingham except for 3-way transferred or forwarded calls, Exhibit 28. A modification of the order terminating privileges was issued March 20th, 2018 to terminate mail, telephone, and visiting privileges as to Culpepper, Exhibit 29. On the day Mr. Knight was sentenced, October 11, 2018, Judge Ryan vacated all orders restricting privileges and access. Footnote 22, visitation by Mr. Knight's sisters. The mother of Taz Knight and Legend Knight and 4 adult children was denied based on institutional security concerns. Wow. Exhibit 27, page 2, lines 20 and 25. Number 5, Mr. Knight was denied his right to counsel of his choice. After the entry of the first privileges termination order, Mr. Knight's contact with the outside world was limited to his attorney record and an investigator, if any, retained by those attorneys, and random attorneys he happened upon in the jail attorney room. These restrictions prevented him from identifying, interviewing, and retaining competent counsel to represent him. He could not call prospective counsel. He cannot write prospective counsel. He cannot receive mail from prospective counsel. And he had been able to find, and had he been able to find competent counsel, retaining such counsel was problematic because he had no access to funds, hence no way to pay counsel. The conditions under which Mr. Knight was held at the jail effectively denied him the right to counsel of his choice. The following is a statement about how Mr. Knight met his attorneys of records in this case. David E. Kenner. Mr. Kenner had a long-standing relationship with Mr. Knight. He had a serious health problem, could not continue to represent Mr. Knight on this case, and Mr. Knight fired him. Brett A. Greenfield, Mr. Kenner's partner, who had no independent relationship with Mr. Knight. Matthew Fletcher. Mr. Knight knew Fletcher from junior high school. Fletcher was in the attorney room at the jail seeing another client and approached Mr. Knight about representing him. Mark Shapiro. Matthew Fletcher brought Mr. Shapiro into the case and he left when Fletcher left. Thaddeus J. Culpepper. Culpepper first visited Mr. Knight with attorney Freddie Sayeg, right? I don't know how to pronounce that.
But, and I only know that because that was my kid's doctor's last name.
Okay, Saeed. Thomas A. Mesereau. Culpepper made initial contact with Mr. Mesereau because Mr. Knight needed a real lawyer. Mr. Mesereau allowed Culpepper to remain as second chair. Sharon Applebaum. Mr. Mesereau brought her into the case. She left when Mesereau left. Stefan Schwartz approached Mr. Knight in the attorney room at the jail and told him he was good friends with David Canner. Mr. Knight later discovered this was untrue. Oh, man, I think they was trying to sick dumb trucks up under him. He lying about being good friends with David Canner. Oh, God, excuse me. Jamal Toussaint. Mr. Knight knew him when he was a sports agent and lent him $25,000, which was never repaid. He subsequently became an attorney, approached Mr. Knight in the jail attorney room, and offered to represent him if Mr. Knight would forgive the loan. Jeremy I. Leeson, Jamal Toussaint's partner who was brought into the case by Toussaint. Antoine D. Williams, brought into the case by Jamal Toussaint and Jeremy Leeson. Mark Leeson, Jeremy Leeson's father, brought into the case by his son. Dwayne Folk, brought into the case by either Jamal Toussaint or Antoine Williams. Dominique Banos, Mr. Knight first met her in the jail attorney room where she was seeing another client. He called her over asking about representation. Mr. Knight's choice of counsel was limited to lawyers who happened to be in the attorney visiting room at the jail when he was there. These visiting room lawyers brought other lawyers into the case, all of which, with the exception of Thomas Mesereau, were not of Mr. Knight's choosing. As Mr. Knight told Judge Cohen, he was forced to use attorneys that nobody in the world would use for a jaywalking ticket. Exhibit 20. The United States versus Gonzalez. How many more pages is this? Damn, what page we on? 29, and it was. Yeah, I think we're gonna get to. Let me finish this section because it's already getting late. It's going on 10:30, and we've been in here for 2 hours, and I don't think we're gonna be. Yeah, I don't think we're gonna be finished. Let me finish this one. This section now. Then we're gonna have to be continued. I think I'll read it in the morning and publish it just so you guys can get the rest of it. But this is very long and extensive legal work. Salute to everybody in the chat who've been hanging around, but I'm going to give y'all that much. In U.S. versus Gonzalez-Lopez, 548, United States Supreme Court, 140, 2006. The United States Supreme Court held that the trial court's erroneous deprivation of a defendant's choice of counsel was a structural error not subject to review for harmlessness. There, the defendant hired local counsel and Mr. Lowe, an attorney who was not from the Eastern District of Missouri. A magistrate judge accepted Lowe's provisional entry of appearance, but revoked it on the ground that Lowe's passing notes to local counsel violated a court rule. Thereafter, local counsel withdrew Lowe's application for admission pro hac vice, denied because local counsel accused him of improperly contacting the government about the case, while local counsel still represented the defendant. The defendant retained another local attorney, Dick Hawes. Lowe's renewed motion for admission pro hac vice was denied, as was Dick Hall's request that Lowe be present at counsel table during trial. The defendant was convicted. The Supreme Court's analysis began with the Sixth Amendment right to assistance of counsel in all criminal prosecutions, and case law holding that a defendant who can afford counsel has the right to choose who will represent him. Seaweek versus United States, Kaplan versus Drysdale, Charter versus U.S. The court squarely rejected the government's argument that in this context, a Sixth Amendment violation requires a showing that trial counsel's performance was deficient and the defendant prejudiced by it. The Sixth Amendment commands not that a trial be fair, but that a particular guarantee of fairness be provided, to wit, that the accused be defended by counsel he believes to be the best. Gonzalez-Lopez, where there is an erroneous deprivation of counsel, the Sixth Amendment right to counsel is violated. No additional showing of prejudice is required to make the violation complete. I bid. California case law is consistent with that of the U.S. Supreme Court. See People versus Williams, U.S. versus Gonzalez-Lopez, which held that the Sixth Amendment right to counsel guarantees the accused the right to retain counsel of his own choosing, and that a violation of this right is per se reversible. A trial court must make all reasonable efforts to vindicate a defendant's constitutional right to counsel of choice and has limited discretion to intrude upon that right. Maxwell versus Superior Court. In People versus Cravati, defense counsel had a heart attack on the fourth day of trial and sought a 2-month continuance so that he could recover. The trial court's response was to appoint the lawyer's partner as counsel and order the trial to resume 1 week later, which it did, over the objection of the defendant and the partner. The Court of Appeal held the refusal to allow the defendant to be represented by counsel of his own choosing constituted a denial of due process and required reversal. Most recently, in People versus Friars, the Second District Court of Appeal reversed a stalking conviction because the trial court abuses discretion in denying the freest fourth request for substitution of counsel involving attorney Edward Yin, although Yin represented that he did not intend to cause further delay in the trial if he substituted in. The court denied the substitution because the case was over 3 years old. There had been previous motion for substitution of counsel that were denied. Substitution would cause delay in the case, and the motion was for purposes of delay. Additional motions to allow Yin to substitute in were subsequently made and denied. On appeal, the court, quoting People versus O'Malley, described the state law right to counsel as reflecting not only a defendant's choice of a particular attorney, but also his decision to discharge an attorney whom he hired but no longer wishes to retain. Because a criminal defendant's right to counsel of choice may be overridden only under narrow, compelling, and specifically de-alienated circumstances, Frias' conviction was reversed because the deprivation of his right to counsel of choice was a structural error. Frias, 98, and then People versus Williams. In this case, the restriction imposed by the court on petitioner's ability to communicate with, interview, and retain counsel denied Mr. Knight his right to counsel of his choice. This was a structural error and reversal is required. Just like the Gonzalez-Lopez case, the People versus Williams, People versus Crovetti, and People versus Frias. So look, check this out. We're going to stop right there. We're almost on 2 hours, 200 people. Salute to everybody who stayed in. Yael, could you take us out? I want to make sure in the morning when you wake up about 9 o'clock Pacific time, I should already have the rest read for you guys or still be reading it. So y'all tap in and then we'll be able to talk about it in the chat. So stay active. Yeah.
Yo, Damu Kiwe Conversations. Hey, man, listen. Y'all done sat through what? 2 hours, 2 long hours of elaborated content. DuseM, that girl Henny, with the great elaboration of this Keefe D paperwork, man. Listen, this Keefe D paperwork is something else. I'm sitting here becoming a student. I've never did Fed time. I don't know nothing about no proffers. I was only educated by DuseM himself, Bomani, Diamond, and everybody else who's been in that system. And being a student of this, snitching and
there you go.
Bringing people in and out. Man, listen, it's a lot of paperwork. We sat through, we got through it. Salute to everybody on Clubhouse for sitting in, tuning in. Salute to all the mods that been on their job, doing that, man. Salute to the Goose, salute to you too. Our valid supporters that have been supporting us since we started, man. Salute to y'all in the chat. Salute to everybody that's in the chat right now. The chat is where it's at. The Blue Wrench Mob, they always is on their job. Like, comment, subscribe, and if you tune in and you like and you love the content, make sure you tell a friend to tap into Damu Kiwe Conversations. DuseM the Don, Bremen, that girl Henny. Brought plenty of Henny tonight, man, with that. We was up with you.
Good night.
In the Kiwe Pop Star, man. Y'all done tuned into another hot live of Damu Kiwe Conversations.
Henny, thank you for reading for us and assisting me. Could you take us out? Like only you do.
But of course. So y'all already know what we say. Thank you all for tapping in and tuning in. Make sure y'all hit that like button on the way out if you didn't hit it on the way in. Love is always love, y'all. When y'all rest well, and we'll see y'all in the next video. Peace, y'all.